Thank you, Mr. Speaker. I rise in opposition to this amendment. Prohibiting employers from federal contracts for violations of the National Labor Relations Act, NLRA, circumvents longstanding compliance procedures and would have a significant impact on federal contractors. The prohibition duplicates existing safeguards in the federal contracting process that already has a system in place to deny federal contracts to companies that break the law. This flawed blacklisting amendment will threaten federal contractors' due process rights because a federal contractor could be prohibited from DoD contracts before a charge has been fully adjudicated. An employer can be found to have violated the NLRA by an administrative law judge, but the employer has the right to appeal that decision to the National Labor Relations Board. Employers also have the right to appeal NLRB decisions to the U.S. Court of Appeals. It is unfair and unjust to bar employers from federal contracts because they have exhausted all remedies of relief. This amendment also provides unfair special treatment to employers with employees who are represented by a union. The amendment prohibitions can be waived if the employees of an employer are represented by a union, giving unionized federal contractors a significant advantage over non-union firms in the federal procurement process. These prohibitions will encourage frivolous NLRA complaints and provide labor unions leverage to organize non-union federal contractors. The federal procurement process works best when the bidding process is open and fair and not dependent on whether the federal contractor is unionized. This is in the best interest of taxpayers. I urge my colleagues to reject this amendment, and I yield back.